This video is about deposing the treating physician. Before you notice the deposition of the treating physician, ask yourself, is this a deposition I should take? Because you'll be preserving their testimony for trial. And often, plaintiff counsel don't want to spend the money or the time to get a physician to appear at trial. So you may only be helping their case and hurting your own. So if you're going to depose a treating physician, make sure that he or she has something to say that is favorable to your case and that undermines plaintiff's damages claims. Before you depose the treating physician, make sure you've achieved and obtained her complete file. Make sure you have everything that her file has so you can review all her notes, all her type notes, and any information that she's procured from other providers, including any films or any studies or diagnostics she's done. If there are films, determine whether or not you need copies of those actual films and procure those as well, because you may have to review them with the doctor. When you're deposing a doctor, you typically go to their office and depose them in their office setting. So make sure there's enough space for everybody involved. Typically, I prefer to depose doctors at the end of the day so that patients are coming in and out and assistants are coming in and out. Or alternatively, sometimes very early in the morning, and on occasion I've deposed a treating physician on a weekend. Once I sit down and prepare for a treating physician deposition, I make sure I know all their terminology. I sit down and study their records, and if there's any words I do not understand or any tests that are performed that I do not appreciate or understand the purpose of, I sit down with a medical dictionary or with Google and try to figure it all out. Also, let's understand that neither me nor you went to medical school, and we're not going to fight the battle of the experts with the doctor. We're not going to get them to agree on things that they studied for many years and that we're basically studying for in an afternoon or a day or two. So get the admissions you think you can get. For example, if there are admissions made by the plaintiff in the medical records, get them to confirm that those admissions are authentic and accurate. If the plaintiff did not complain of certain complaints that he's complaining of in your case, point that out. Point out that the physician would have written down any complaints the plaintiff made. There are no complaints regarding that specific issue, and therefore the plaintiff did not make those types of complaints. Also, sometimes physicians treat plaintiffs in a vacuum. They don't have all of the relevant medical records. And so look at the other records and see if somehow they may augment or change the expert's opinion. Physician may say or opine, for example, that the plaintiff's injuries are related to an accident, but not be aware that the plaintiff has had similar accidents in the past and has been treated for those accidents in the past. When confronted with prior medical records, that physician may change his or her opinion. They may not, but it is a good time in deposition to explore that. And remember that with regards to an expert, if you procure favorable opinions that favor your client, you want to lay the foundation that the doctor is an expert. You want to go through their credentials, their education and training, so that if you do read the transcript, there is a basis for their expertise.